lands. What are public lands? Where did they come from? For the next 150 years, Congress enacted hundreds of statutes for the purpose of disposing of these public lands to the actual occupants and settlers. The term public lands was clearly defined by the Supreme Court to mean, and you can look this up, and I do want you to. I want you to. Go to your courthouse, go to an attorney, go anywhere where you can get access to Westlaw or any legal source. There are three sources that judges look at when they want to know the meaning of a word or a term. Corpus juris, if you're taking notes, you can write this down. Corpus juris secundum, American jurisprudence, or words and phrases. And you can even go to Black's Law Dictionary and look up the term public lands. It has a very clear, unambiguous, and indisputable definition. It's been reviewed by the Supreme Court on at least 16 separate occasions. And the term public lands means lands open to entry and settlement upon which there are no rights or claims. Okay? Now, if you go into a court of law, and I have seen this, personally witnessed this dozens of times, if you go into a court of law arguing about grazing on public lands, you have already lost. Why is that? What is the definition of public lands? Lands upon which there are no private rights or claims. You can't claim you have a right on public lands. So if you get sucked into an argument in court over your rights on public lands, it is contradictory. The principal policy of Congress was to grant to the head of a household, and this is right out of the statutes. Look up the Homestead Law. Okay, look up the Reclamation Act. Look up the Desert Land Law. Look up the Stock Raising Homestead Act. This language is in there. The idea was not to grant 160 acres or 320 or 640. It was to grant to the head of a household or to sell at nominal cost under the preemption laws, and that was repealed in 1891, excuse me. After 1891, you couldn't buy land. You could only get it under homestead law unless you had already initiated a claim under the preemption laws. Okay? But after 1891, you had to settle on the land, mix your labor with it, live there for whatever the required amount of time was in order to earn that land and make it your property. Agricultural homesteads of, quote, a size sufficient for the support of a family. Well, as time progressed and settlement progressed towards the west and became more and more congested with various people claiming areas, and with the fact that there were these range laws in the west where once you had settled there, and this is what the Supreme Court has said on numerous occasions, is once that land has a claim attached to it, I go out there, I cut down those logs, I build a house, I settle on there, I mark the corners so that everybody knows that's my claim. Legally, the title is still in the United States. I haven't proved up on it. I haven't been issued a patent. I haven't even filed my claim yet. But yet I am in possession. I have occupancy. I am using it and I have improved it. Those terms all have meaning in the law when you read these laws. Okay, it's taken, the moment that happens, that land is taken out of the category of public lands. Remember, that's part of the definition. Is it open to entry and settlement upon which there are no prior rights or claims? Once I have occupied that land, nobody else, those were people called claim jumpers. They would come on and try to file a claim for a piece of land that somebody else was already in occupancy of. And the Supreme Court said, that is contrary to the whole concept of acquiring property under the laws of the United States. And so even though the legal title might still be on that land, as long as I was in the occupancy of that land, nobody else could come on there. And it was taken out by operational law, automatically taken out of that category, that classification of public lands. And the Supreme Court has spoken on a good case to read, to really understand a concept. This case called Barden versus Northern Pacific Railroad Company. And the Supreme Court said it is well-settled law that at the moment a right attaches to the public lands, it ceases to be public lands. And there's a lot of case law on this concept, okay? When does public land cease to be such and become private property? Well, I just covered that, but it's well settled that all land to which any claim or rights of others is attached does not fall within the designation of public lands, where the United States grants a right-of-way by statute to a company which files a map. This is almost, I didn't put it in quotes, but this is basically the quote out in Barden versus Northern Pacific Railroad Company, which files a map, a definite location, and the road is constructed. The land forming the right-of-way is taken out of the category of public land, subject to preemption and sale, and the land department is without authority to convey rights therein. And there's another very important case, Atherton versus Fowler, in 1877, and that was important because it dealt with a rancher who had claimed land that he had bought, thinking that it was covered by a Mexican land grant. And it later turned out that the land grant was had not been certified as a legitimate land grant by what was called the Court of Private Land Claims in California. And so even though he was claiming thousands of acres of land under what he thought was a valid Mexican land grant, it was later found not to be. And so overnight, and this is in that Atherton versus Fowler case, overnight people literally went onto the land, erecting a house with no windows or doors, just throwing something up so that they could come in and claim, that they were in occupancy. And so one of these cases, one of these individuals, it went to the Supreme Court, and the Supreme Court said, that's even if the title is in the United States, and even though that guy has done no improvement to this land other than using it for forage, he still has possession. And this is not public land. And you cannot come in there and settle on there claiming under the land laws of the United States, because the land laws, the settlement laws of the United States apply only to public lands. And public lands are lands that are open entry and settlement upon which there are no prior rights or claims, and therefore this is not public land. Even if the title be in the United States, and even if the amount of land far exceeds that's granted by the federal laws, it is still not public land.